Good morning, good afternoon, good evening to everyone, and welcome to this webinar on the advisory opinions on climate change and the way to move forward. So my name is IACtHR. I'm professor and visiting research professor at the Center for International Law, National University of Singapore. That's really my pleasure to be and to act as a moderator of this panel. I'm also a member of the UN Human Rights Committee, and as such, I have been directly involved in some of the cases that have to do with climate change and human rights, or climate change and the right to life, and climate change and privacy, et cetera, et cetera. So it's really a pleasure to act as moderator. And I will immediately give the floor to Danielle Yu, which is the CIL lead climate change law and policy, and the master brain behind these seminars and webinars on climate change. So started in July this year when the ICJ delivered its own advisory opinion. So Danielle had this idea of organizing different webinars on the advisory opinion of the Inter-American Court, but also advisory opinion of the ICJ, and now the way to move forward. So Danielle, you have the floor.
Thank you very much, Helene. Excellency, Ambassador Simona Fuentes, Excellency, Ambassador Anita Ajvini Wahid, distinguished speakers, colleagues, friends, participants from across the globe, and indeed we have a couple of hundred today. Good day, good morning, good afternoon, good evening, wherever you are across the road. On behalf of the Center for International Law and my director as well, who is here today with us today, it is my utmost pleasure and delight to welcome you to this final installment of the CIL's three-part webinar series for a deep dive on the recent series of advisory opinions on climate change, delivered by, firstly, the Inter-American Court of Human Rights, and secondly, the International Court of Justice. We are particularly privileged and honored to welcome to our panel today Ambassador Fuentes and Ambassador Wahid, and thank you very much for making the time to join us despite your busy schedule. The question here is, what do these series of advisory opinion portend for the future of global climate action and international lawmaking? We at the CIL, it's just me and our colleagues, we had conceived of this series with a few objectives in mind. Apart from a deep dive on the legal questions considered by the court, we also aimed to explore through this dialogue the questions of implementation. The questions are both from the point of states, how they may give effect to the findings through national, regional, or international legal mechanisms, and also for companies as well. How do they adjust their corporate strategy and action in line with court's decisions? Secondly, we wanted to examine the treatment of international economic law, in particular, how international trade or investment regimes is, or perhaps is not, addressed in the advisory opinions, and what this means for the legal landscape going forward. Third, how can these legal arguments be crafted based on the advisory opinions to support or strengthen climate-related claims in ongoing and future proceedings? Given that the CIL is situated in Asia, we are particularly keen, of course, as well, to bring an Asian and ASEAN perspective and voice to the debate and situating these discussions within the regional, the legal, political, and institutional context. In the first webinar convened on the 30th of July, our distinguished panel focused on the advisory opinion issued by the Inter-American Court of Human Rights on climate emergency and human rights. And the discussions there address, among others, the mobilizing effects of the language of human rights to push states to be more ambitious in addressing the climate crisis, and how the court sought to address the imbalance traced to the disproportionate effect of climate change suffered by states that have contributed minimally to the climate emergency. The panel also addressed the legal innovations employed by the court and its broader implications for environmental justice, among others. The second webinar, convened on the 5th of August, focused on the ICJ advisory opinion on the obligations of states in respect of climate change. And this brought together another distinguished range of experts to unpack the advisory opinion and to explore its legal, political, and policy implications, from treaty interpretation and customary international law to climate litigation, state responsibility, global equity, the panel offered diverse perspective of how the advisory opinions may shape the future of climate accountability and environmental justice. Now, we have now come full circle in a sense, reuniting the themes in webinar 1 and 2. And this panel today will take stock of the two advisory opinions and discuss their wide-ranging legal and policy implications for states, individuals, and corporates, including the implementation of the opinions, as well and the likely interactions with international economic law, the impact of the opinion on judicial and arbitral proceedings relating to climate justice. In particular, from a regional ASEAN perspective as well, we examined how this has an impact, perhaps in the area of human rights. So with that, I will turn over the proceedings back to our Center Director, Dr. Nilofer Oral, and look forward to a fascinating and an engaging dialogue. Thank you.
Yeah, thank you so much, Danielle. Thank you, Hélène. Also, a warm welcome to your excellencies for joining us, and of course, our head of our international economic law and policy, Janssen, and all of those who are joining us online. I have the great privilege of being the director of the Center for International Law. And I have to thank, of course, Danielle for putting together this trilogy of webinars on advisory opinions that I think we will be talking about for a long time. I was recently at a seminar conference on climate change, and someone said they had read, the advisory opinion 3 times, and each time they see something new, they read something new. Even though there's a lot going on there, I don't think we can have too much of these webinars, really. And particularly, I think today, having the ambassadors here from us, from ASEAN, and from getting the state perspective as well, very important, because at the end of the day, ultimately, these advisory opinions will have an impact, we hope, on states. So there's a lot still to unpack, and I think, Danielle, you've outlined it from states, but also what does this mean for corporations as well, private actors. So I think that this will be a continuing conversation we will have and we should have. And I'm really pleased that CIL is taking the lead on this and the very able leadership of Danielle. So I just wanted to express my warm welcome to all of you, and thanks to our panelists for joining us, and to all of you joining us from around the world. And I also look forward to this discussion. So over to you, Hélène or Danielle.
Thank you, Danielle. Thank you, Nilofer, for your kind words. And I agree with you both. I have the impression that we started actually this conversation in July, probably not the very same day the advisory opinion of the ICJ was delivered, but the day after. And it's a continuing conversation. And CIL also was the co-organizer of another webinar dealing, and we will probably discuss about the African system, but dealing also with the pending request for an advisory opinion by the African Court on Human and People's Rights. So it's really very important to be part of this conversation. And another element that is also very important is that it's a global conversation. So CIL, of course, is at the center of this global and universal conversation on the climate change advisory opinion. So thank you very much for bringing all these perspectives together in these webinars. Now I turn to our very distinguished panelists, and I'm really grateful they were able and they have been able to be present with us to share their views as practitioners, but also as litigators. For Francesca, I will come back to her. It's very important because, as Danielle said, now we are also focusing more on the implementation. What are the next steps? What are the expectations based on these different decisions, advisory opinions? I just have to say that one of our panelists, Professor Margareta Vevering Singh cannot, unfortunately, be with us today due to personal circumstances. So I'm just bringing from her part her apologies. I'm turning immediately to Ambassador Fuentes. Excellence, thank you very much for being here with us. So Ambassador Fuentes is Ambassador of Chile to the UK, and we know that Chile actually has played a very critical role, of course, before the Inter-American Court, because Chile was one of the two states raising the question before the Inter-American Court, but more globally, Chile plays a very significant role in this climate change dialogue, climate change discussion. So Ambassador Fuentes, thank you again for being here with us, and you have the floor.
Well, first of all, thank you very much for the invitation. It is a real privilege for me to be participating in this webinar. Thank you to the National University of Singapore, the Center for International Law, for organizing and being very active in trying to spread more knowledge and debate about these advisory opinions. Despite the fact that these decisions have only an advisory role and they are not obligatory, I think that they will have a great impact because they are promoting a great debate. And that debate, of course, will influence decisions, binding decisions at the domestic level, and also probably at the international level before international courts or international courts of arbitration, particularly perhaps in the field of investment protection. So first, I would like to start by the motivation behind these requests for advisory opinions. You know, Chile and Colombia have taken the lead somehow in requesting these advisory opinions. They have been very active before the Inter-American Court of Human Rights, and very active also before the International Court of Justice. I would like to make a comment here, because if you look at the advisory proceedings of the International Court of Justice in the past, there's something very interesting to observe, but is that only a few states usually appeared before the court. Because, of course, advisory opinions or to be before the court involves a lot of effort. Therefore, only the states that were really, really connected to the question usually appeared before the court. And this time, we had a number that was really out of boundaries, you see, of states participating. And I'm very glad that Latin American states, which usually stayed a little bit behind for many reasons. One of those reasons is language. I mean, to prepare a statement before the court in English, to prepare the written presentations takes a lot of energy. And this time, many Latin American countries appeared before the court, among them Chile and Colombia and others. So the motivation to appear before these courts and to exercise this right to request an advisory opinion, I think shows that certain countries want to show that they are exercising leadership in the field of environmental protection. This is the case with Chile and Bolivia. Also, leadership in the protection of human rights. So the connection between environmental law and human rights, it is very interesting to stress that connection in the desire of states to participate. Now, in particular, developing states such as the Latin American states and countries from the Caribbean show that there is an imbalance in the distribution of political and economic power, not only between states, but also within their societies. Therefore, in our countries, the legal system and the judiciary have been very relevant in the protection of human rights. Sometimes the political system is unable to overcome these disparities in power. Therefore, the courts appear as holders of power in order to at least try to correct the consequences of this maldistribution of power. So in this context, the Inter-American Court of Human Rights occupies a place of privilege insofar as the prospective impacts of its case in the domestic systems of our countries. It is usual that domestic courts within the Inter-American context tend to quote decisions of the Inter-American Court of Human Rights in their decisions. Therefore, they are really an engine of change, backed up by the jurisprudence of the Inter-American Court. So definitely then, this advisory opinion by the Inter-American Court of Human Rights has an enormous potential for advancing environmental rights within the legal system of the member states. Now, what does these advisory opinions say about the obligations of states with regard to greenhouse gas emissions and the deleterious effects on the climate system? Well, first, I think that one of the main and very important conclusions that we can draw from these advisory opinions concerns the relationship between the UNFCCC regime and other international obligations, including customary international law. So it's very important that now we have this authoritative view that the UNFCCC regime is not a self-contained regime, that the obligation not to cause harm to the environment or not to cause harm to human rights has an independent role to play. Therefore, the system, because the UNFCCC system, in a way, is today, under the Paris Agreement, based on voluntary commitments, the NDCs. So this system of voluntary commitments that helps in reducing greenhouse gas emissions does not make states immune to claims regarding breach of other treaty obligations or of customary law obligations outside the UNFCCC regime. That has a big, I think, potential for other developments in this field, particularly because it may prompt states to enact legislation in this sense, or it may prompt more litigation before human rights courts, before domestic courts. Now, the Inter-American Court advisory opinion contributes really to clarify that the obligations of states with regard to the protection of human rights in the context of environmental damage is a very stringent obligation. Therefore, if you read the advisory opinion, you would see that the court uses the language of a strict obligation. So it's not only an obligation not to cause harm, because it uses the language strict obligations. So from there, we can see that there's enormous potential for lawmakers also, that probably can move a little bit further regarding obligations, setting obligations, but also setting the consequences of the violation of those obligations. With regard to the ICJ, I think that it is, again, very important that the ICJ has also made this distinction between the UNFCCC regime and the obligation not to cause harm. Therefore, developed states, the developed world, are expected to continue enhancing their efforts to reduce emissions. And NDCs, again, are not entirely discretionary. There can be, after reading the decision, the idea is clear. States may incur in responsibility, liability, in the field of human rights, but also in the field of having to pay damages. I'm very glad that the ICJ has entered into questions about liability for loss and damage, and has dispelled any doubts about the interpretation of Article 8 of the Paris Agreement, and has concluded that there is not any waiver of responsibility in the language of that article, and that attribution of responsibility is something that might be established. So I think that I could stop here because it's only 10 minutes, so that we can continue later with more points to tackle. Thank you very much.
Thank you. Thanks a lot, Ambassador Fuentes. And it was really, I mean, you have stressed a lot of very important things, but what I take from your intervention is first, indeed, what was extremely important in both advisory opinions is to stress the relationship between human rights and climate change. These are not questions that are separated, but on the contrary, they are interdependent. The other element that is very important, and of course we will see how it impacts, is what you said about the transformative role of the Inter-American Court of Human Rights decision. Indeed, these are advisory opinions, but as you rightly said, even advisory opinions might have a very, very impactful role in the domestic system. So let's see how it goes. And the third element in your presentation that is also very important, and we will have to reflect upon this, is what the Inter-American Court also said about breaking the silo. And breaking the silo between different fields of international law. So, as you say, the UNFCCC, and other fields of international law, treaties, and customary norms. So, thanks again for bringing these elements into our conversation. Now I move to Ambassador Wahid. Thanks again for being with us, Excellency. You are the Indonesian representative at the ASEAN Intergovernmental Commission of Human Rights, and we know that indeed climate change is a current and pending questions discussed by the Commission. So thanks for being here. Thanks for bringing your perspective, especially in this implementation of advisory opinions in the Asian sector. You have the floor, Ambassador.
Thank you very much, Professor Helen. And also thank you very much for CILN and US for having me here, for inviting me, and for hosting such a very important webinar and very, very relevant to our challenges that we are facing nowadays. I'm actually very much looking forward to learning from other experts as well, because I know that even though I'm bringing somewhat of an ASEAN point of views in this matter, but I'm also looking forward to having a more robust understanding of what's been going on other part of the world, as well as the way experts on this topic really sees the problem. So thank you very much for allowing me to provide some sort of an idea of what's been going on in ASEAN in relations to the advisory opinions of ICJ and IACRT. Is it correct if I'm not mistaken? IACTHR. I am sorry about that. It is an honor to join this panel. So as we know that the recent advisory opinions of the International Court of Justice and the Inter-American Court of Human Rights are truly historic, as for the first time, the world's highest courts have clarified that climate change is not only an environmental challenge, but also a matter of human rights and state responsibility. So for ASEAN, these opinions are not just abstract. So because these go to the heart of our region's struggle with climate change, because this is a struggle that for quite a while now has already been shaping the lives and people's livelihoods and futures as well. And if we are looking at the advisory opinions, there are several key takeaways that I think worth to be touched right now. Some I For me, at least four messages that are very crucial that needs to be addressed. Is the first one is that all states have obligations to prevent climate harm, regardless of which treaties they have signed, whether in the past or planning to sign future treaties. The second one is that these obligations are erga omnes, in which that we owe to the entire international community instead of just the people of each individual state. And the third point is that states must guarantee procedural rights, which involve making sure that there is access to information, there is public participation, and of course, the protection of justice. And the last point is that that failure to act on climate change is not just poor policy, but it also may amount to an internationally wrongful act. Although right now, I think most of the states will not look into the direction of this potential implication. But if we are looking at the realities of the ASEAN's climate and human rights, I think there are several points that also need to be addressed. The first one is Ms. Danielle Yeo has already touched based upon a little bit on how ASEAN is the region where there is a disproportionate vulnerability when it comes to the climate crisis, because Southeast Asia is one of the most climate exposed regions, and we've seen that there are different threats and different vulnerability of countries as well as cities. For instance, we are looking at rising seas that threaten metropolitan cities, threaten certain areas in major rivers of the region, and we've seen some countries that are very much affected by extreme typhoons. Some other countries were affected by droughts, and some other countries are also implicated a lot by transboundary haze and wildfires. So these are the disasters that impact basic rights. We've seen how the people's housing, access to food, access to health, and even the right to live is also impacted by this disproportionate vulnerability. And if we are looking at the governance of the way the governments of the states address the issue, we are looking at some gaps that exist, because many ASEAN states still rely on coal, oil, and gas for growth. And transition from this coal, oil, and gas to a more sustainable source of energy may threaten the livelihood of the people in terms of the job security, subsidies, and etc. And we are also looking at the gaps in which that most ASEAN states have already laws that exist, but the enforcement is, of course, vary across the states, but enforcement is generally weak. And we've seen also the practices of corruption and business government that limits climate emission as well. And then we are also looking at some of the regional efforts that has been in place, like the ASEAN Agreement on Transboundary Haze, the Environmental Rights Declaration, and some other instruments as well. they lack teeth because, of course, this is not legally binding, and there is no obligations for any states to follow this. And these regional efforts are basically focused more on cooperation than binding commitments. And on the other side, I'm very much happy to say that to say that civil society has been very vocal about this issue. When it comes to the advisory opinions of these two courts, civil society has been in support of this. For instance, Energy Shift Southeast Asia hailed the ICG opinion as a big beacon of hope for frontline communities. Some other activists, for instance, I'm quoting here Jerry Arances of the Philippines CEED, emphasized that the law is clear and it demands immediate action to protect people and communities. But at the same time, on the other side of the coin, we see that civic space remains constrained. So we are very proud to see that civil society has been vocal, but there is also constraint that is being imposed towards civic space as civil society, even though the courts stress that participation and access to justice are preconditions for effective climate action. So why these two advisory opinions matter for ASEAN? Because, well, I agree with what Her Excellency Fuentes had already said, that this could make a real difference because they provide legal leverage in which the NGOs and domestic courts in several countries can now argue that climate inaction is intentionally wrongful act. And these advisory opinions also provide human rights framing, because now ASEAN, because we know that for a while now ASEAN has avoided calling climate change rights issues. So these opinions make that link unavoidable anymore and strengthen the case for IACtHR to put climate justice in our agenda. And these opinions also matter for ASEAN because they provide state responsibility and litigation risk, because that means that ASEAN governments face higher risk of lawsuits domestically and internationally. In domestic environment defender groups may raise this issue to courts, and internationally claims for damages caused by neighboring states can also be brought to surface. And they also provide responsibility and litigation risk for corporations, in which case the coal, palm oil, or mining corporations, which can also be targeted by these opinions, since states are expected to regulate them under due diligence standards. So the last one is that they generate diplomatic pressure as well, because vulnerable states can now point to the opinions in pressing for stronger cooperation and finance. And hopefully, in the near future, ASEAN's silence will become harder to defend as courts worldwide affirm binding obligations. So at the same time, I think we also need to be realistic, because the advisory opinions impact may also be limited, because of course the opinions are non-binding. And as we all know, the ASEAN sovereignty norms allow governments to downplay them as well. The political economy of fossil fuels remain strong, and some countries rely heavily on coal, and the transitions from that threaten jobs and subsidies. And institutionally, ASEAN has weak enforcement mechanisms. So instruments like the ones that we already have are consensus-based, and basically still under the main principle of ASEAN, which is non-interference principle, that can be used to avoid any request to be accountable. So, but there are things as well that we can realistically expect from ASEAN, because of course these advisory opinions will not force immediate compliance in Southeast Asia. But I think for me, I'm an optimist, so I think they will also shift the baseline in the region. Governments now know that courts, civil society, and international partners have authoritative texts to hold them accountable. And they may create soft pressure in diplomacy, in finance as well, and will, of course, impact the reputation. And these opinions may also empower judges, activists, diplomats to push harder within domestic and regional areas. So over time, I'm optimistic that this combination can be transformative for the region. So looking ahead, later this year, we know that the African Court on Human and People's Rights will issue its own advisory opinion, if I'm not mistaken. Please correct me if I'm wrong. So together with what has already been released by ICG and IACtHR, this could create a powerful global South jurisprudence. So the question for ASEAN is whether to remain cautious or to seize this moment. We have already some instruments, albeit weak in implementation. We have the Hays Agreement, the ASEAN Climate Finance Strategy, the new ASEAN Center for Climate Change, the Declaration on Environmental Rights, but of course they still remain weak. But the advisory opinions give us an opportunity to make these frameworks stronger, binding, and more people-centered, as it is the focus of the ASEAN Community Vision of 2045. One other thing, IACtHR has just finalized the ASEAN Declaration to the Right to a Safe, Clean, and Healthy and Sustainable Environment. It is not being adopted yet. Hopefully, it will be adopted next month during ASEAN Summit, which I hope and believe that this declaration will add to a stronger call for commitment and people-centered policies for ASEAN jurisprudence. So I think the message from the world's highest courts is clear, that climate obligations are binding, supposedly binding. It is owed to all, to every single person on Earth, not only the citizens of each member countries. And failure to act may constitute a wrongful act under international law. But in ASEAN, realistically, we know that these opinions will not flip a switch overnight, but their true power lies in empowerment. By arming civil society, strengthening the courts, and providing vulnerable states with legal arguments so that we can raise the reputational cost of inaction as well. And we can start planting human rights firmly at the center of climate debates. So in time, even in our cautious regional landscape that we have right now, that combination can be transformative in the future. So I'll stop there, and hopefully we can discuss further in the Q&A session. Thank you.
Thank you. Thank you. Thanks a lot for your amazing also presentation and for bringing both, I would say, very realistic, but also very optimistic view, because so I didn't know about this. So the declaration is not published, if I understand correctly, the ASEAN declaration. It will be released next month when adopted by the Commission, right?
Well, it is. It waits. The mechanism is that once it is released and adopted by IACtHR, it has to go through the AMM, the Foreign Ministers Forum of ASEAN, and if it is agreed by the AMM, then it will be adopted by ASEAN.
Okay, wonderful. So it means that by the end of 2025, we might have also a declaration on that. Now, very important also what you said about the advisory opinions. Indeed, they are not binding, but you presented the advisory opinions as a sort of empowerment tool. So for diplomats, for civil society, for judges, domestic tribunals, judges, and so on. So it's really important to keep this in mind, because indeed they are not binding. So we have to to be realistic, as you said, but they might be also a tool to be used by different actors. It was also very important to hear from you that when we talk about climate change, we do not talk about theoretical questions, but you really developed that indeed the Asian region is the most, so I'm quoting you, the most climate exposed region, and there is indeed a disproportion in terms of vulnerability. And what is also very important in your presentation is what you said about procedural rights, access to justice, what the Inter-American Court called environmental democracy, based on access to justice, but also the role of civil society, protection of environmental defenders, and so on, the protection of civic space also, and so on and so forth. So thank you very much for this perspective. And it was actually the perfect way to move to Francesca Mingrove. So Francesca, I would say in our panel, we represent the voice of civil society. So Francesca is the senior attorney of the Center for International Environmental Law based in Geneva. So I know that this center is extremely active in Geneva in raising awareness on this relationship between climate change and human rights, as the previous panelist said. And also the center is very active in terms of strategic litigation, but also, so it's not only about strategic litigation, but it's also setting the standard. So for instance, pushing, because the Council of Europe and European continent is quite late. So also pushing in the current discussion within the Council of Europe for the adoption of a binding instrument dealing with and protecting the right to a healthy environment. So Francesca, I know that you are extremely busy. Thanks again for being part of this panel and for bringing what Ambassador Wahid said about the role of civil society. So the floor is yours.
Thank you very much, Hélène, and it's really a pleasure to be part of this panel. Maybe a slight disclaimer, as you mentioned, I'm based in Geneva, so I interact with many human rights institutions, and I guess my role was indeed to help lay the ground for these really landmark advisory opinions. I'm not involved myself in primary or secondary litigation, but I'll do my best also to elevate some of the points from colleagues. But definitely what you said is really important about this kind of step-by-step approach, and really making sure, and that's what we've been doing for the past years, making sure that the ICJ, the Inter-American Court of Human Rights, we didn't mention the EAT loss, but also its own advisory opinion had an impact in some of the reasoning. And now looking ahead, hopefully the African Court on Human Rights can really build on what has been said, so by the Human Rights Committee, for instance, which we always look at in terms of really establishing standards and furthering the interpretation of what states' obligations are when it comes to climate change and human rights. And Ciel, my organization, has been really involved in all the advisory opinion proceedings across the 4 courts, and really partnering with NGOs, civil society, but also states in crafting and thinking through some of the key arguments. I'm sorry that Margarita is not there, because I think she would have made a wonderful job at really unpacking some of the landmarks outcomes of these advisory opinions. And maybe we can take a step back and identify some of the key areas that have been clarified by these advisory opinions, and how also litigation can help move forward on this dimension. And maybe a point on litigation. This is an argument that we keep hearing, that litigation will mount also as a consequence of these advisory opinions, or as a potential consequence of a legally binding instrument under the Council of Europe. But we know that climate litigation is happening already. As of the first half of 2025, more than 3,000 climate proceedings have been filed. So this is really something that is happening already. Definitely the advisory opinions are providing clarity on some of the arguments and will be used as a basis. But this is a process that is already going forward. And also on the standing of these advisory opinions, of course, they're not binding, as we know, but they do interpret binding law. So we should not also discard really the authoritative power and the standard setting role that these advisory opinions have. Looking at some of the, it's hard to unpack, and it's also so important to have so many events, also some of them that you're organizing, as you mentioned, on really unpacking the content of these advisory opinions. We're doing the same here in Geneva, also to allow the diplomatic community to really understand what the implications of these rulings are. But definitely there are some elements that we can consider, and since Margareta, I guess she would have talked about it, maybe we can flag some of them. Some of the panelists, I think, already mentioned the question of applicable law and the fact that now human rights are central. So there is not this lex specialis approach, but really the courts follow this harmonious interpretation approach, whereby all relevant obligations apply. And so all different bodies of law should be applied and interpreted harmoniously, because they all aim for the same goal, which is ultimately the protection of human rights, the protection of sovereignty, statehood. Statehood and sovereignty is also a key element. The ICJ looked at that. I'm very glad also that we have Niloufer here, because the report of the International Law Commission also shed important light on what happens when a territory disappears. And this is something that definitely the legal community should delve into further. And I can imagine that also litigation can help with that. The question of non-refoulement, interestingly, the ICJ opened the door for the application of this principle in the context of climate change. And indeed, they also referred to a case before the Human Rights Committee, IACtHR versus New Zealand. So you also see this kind of puzzle that keeps being combined and created. Fossil fuels are a bit of a taboo when we talk about climate action, unfortunately, because we say a lot that states have the obligation to mitigate climate change, to protect populations from it. And yet, at least in some of the political frames here in Geneva, for instance, we haven't managed to have a single Human Rights Council resolution on climate change that mentioned fossil fuels. And the courts did make important statements on fossil fuels. Looking, for instance, at the ICJ, there is a powerful paragraph in the advisory opinion that really looks at fossil fuel production, consumption, granting of fossil fuel exploration licenses, provision of fossil fuel subsidies. So it really goes into detail in what conduct states have to put in place, and also what conduct may mean and correspond to a breach of international obligation. The question of how the science can inform the interpretation of states' obligation was very clear now that we have enough data and enough understanding of the science behind climate change to understand what kind of conduct by states can be expected, and what is can be deemed insufficient, and so which triggers potential legal consequences. The question of future generations, intergenerational equity, in that the Inter-American Court of Human Rights was particularly powerful in really establishing that future generations have rights and states also have obligations in that sense. The right to a clean, healthy, and sustainable environment. Now we have the world's highest court that authoritatively said, sorry, this is always a very difficult word for me to, to pronounce, but it says that now the right is part of the international body of human rights law, and it's also integral to the protection of other protected human rights. And then the question of the legal consequences, reparation. This is a dimension that hadn't really been explored and built out enough in the past. But finally, we have a clear affirmation that states do have obligations to provide reparation if harm is caused. And so I can definitely see how potential litigation can also help define what is meant by the question of loss and damage, what kind of reparation is needed beyond just financial support. And of course, looking at the types of litigation cases, there's a wide array. We can look at state to state, transnational, regional, at the local level, individuals versus the state. And even though, of course, these advisory opinions have been released only very recently, we already see some of impacts in current cases. In the African context, it's quite interesting, for instance, to see that in a case against Shell's offshore drilling in South Africa, already Natural Justice and Green Connection are using the ICJ advisory opinion in support of their claim. Apologies. And in Brazil, recently a federal court of Rio Grande do Sul ordered the suspension of licenses for coal plants. And we understand also that part of the reasoning behind was what was said by the Inter-American Court and the ICJ. I'm sorry, I have a bad cold, so I will just drink a glass of water and I'll keep talking. I'm very sorry about that. So all of these elements and these dimensions can really also trigger some ideas for potential cases, also looking specifically at which operations are not compliant with these obligations. I didn't mention the role of corporate actors. This is something that we are increasingly looking at. The question of corporate conduct, greenwashing is something that has been also looked at by the ICJ and the Inter-American Court of Human Rights. There are some paragraphs in the latter that also look at the interference of corporations in policymaking. And this is a dimension that is often overlooked, but it has incredible impact on undermining also policies. I think one of the panelists is touching upon or touched upon already on investor-state dispute settlement or broader trade agreements. And we see there are some structural barriers for states also to implement better policies to protect the environment and human rights. And in fact, I think Justice Cleveland also made a reference to the ISDS in investor-state dispute settlement and how this has a chilling effect on more ambitious policies. So looking at the African context, I think, Elena, you asked me to have a sneak peek on that. Since we're talking about the advisory opinions that have been delivered, I think it's also worth looking at a potential advisory opinion that will be delivered. And indeed, in May 2025, a petition was filed before the African Court of Human and People's Rights, not by a state, so this is quite a different process, but by the Pan-African Lawyers Union, supported by a wide number of CSOs. We don't know the timeline yet. Based on practice, it can really change from a few months to a few years. I'm very sorry. But what has been really a landmark achievement is the petition itself, because it really kind of shift the approach that this kind of processes are state-led. Of course, we know how central the youth movement from the Pacific, but also globally, was in really creating the momentum for the advisory opinion by the ICJ. But eventually, that was requested by a resolution brought forward by a state. In this case, the process is shifted. The petition is the result of a very participatory and collective process. Many African organizations gather physically in Sierra Leone, in Tanzania, to really draft the petition and making sure that the request was grounded in the reality that is felt in Africa. And this can be seen also in the petition itself. It's a pretty long document. It's more than 60 pages. And it delves also quite in detail in the factual reality of climate change, looking at the impacts across the different regions of the African continent, across different groups. And the series of questions also are based on this factual background. For instance, it's asked to the court to clarify what the obligations are of states vis-a-vis vulnerable groups. They mention specifically indigenous communities, human rights defenders, women, children, future generations. Some of the questions look specifically at just transition. So what is asked of states to put in place an effective just transition? We heard about the ASEAN region that is also dependent on fossil fuels. The African context is as complicated because, of course, we know it's one of the most vulnerable continents to climate change. But at the same time, some of the economies do rely on fossil fuel production. There is the question of historical responsibilities. And in fact, one of the questions aims to unpack what are states' obligations with regard to the duty of international cooperation, also vis-a-vis historical emitters. So all of these questions that are going hopefully to be unpacked really ground the African context in the wider system. And one of the questions as well does look at the role of non-state actors, including multinational corporations. And this, once again, is something that we really hope the African court will look at, because we see also in terms of financial policy-making power, there is an imbalance of power often between state and non-state actors, even if this imbalance is not seen necessarily. And so just to conclude, there are a few lessons learned that can be taken from the previous advisory opinions. Definitely the hope is that the court will build on what has already been said and will go specifically further looking at the specific challenges of the African continent. But also we have online a wealth of arguments that have already been published by states when they intervened before the court in the previous advisory opinion proceedings. And this is so useful, not just for litigation across different levels, but also in the preparation of arguments when it comes to providing inputs to the African courts. So definitely the idea is that whatever comes out of this process builds on what has been created so far and established so far by the courts, and also puts the centrality of communities at front. International law is no longer something that only a few international lawyers can deal with, but it's really the product of collective ownership and work, and that can also be used to dismantle some structural issues, colonial legacies, inequality. So I think the very fact that this petition didn't come from a state is a powerful message in that sense. I will stop there. Thank you so much. Apologies for the coughing. I'm really doing my best. But yeah, and thanks again for convening this space.
No, thank you, Francesca. I didn't know you were sick, so thank you. I mean, you deserve even more our gratitude for being with us and bringing indeed this perspective that echoes what was said previously, especially by Ambassador Wahid about the role of civil society, but also I really appreciate what you developed at the end about empowerment, because indeed, I mean, it's good to have support from states as before the Inter-American Court, because at the end, I mean, the implementation process will require also the support from states. But as you said, that's a collective ownership. And it's very important to have all actors involved, and thank you very much for bringing this also into the conversation. We had a couple of weeks, I think 2 weeks ago, CIL was also the co-organizer of a webinar with African colleagues, and especially the legal advisor of PALU, so the NGO leading this request for advisory opinion before the court, the African court. And they just told us that now the advisory opinion was sent to the states, and all person interested in the process can send amicus brief before the African court. So we have, I think, 3 months to send our brief and or thoughts or input to the African court, because, as you said, one of the challenge will be precisely to insist on the African specificity. So thank you very much for bringing all this, and also the role of science, intergenerational equity, the obligation of reparation. I'm sure these questions also will be addressed by the African court, precisely because the legal basis and the African Charter is a bit different from the American Convention on Human Rights. So again, I'm really grateful, because you were not in a very good shape, but you did very well and excellently. Now I'm giving the floor to our final panelist, and then we have already a lot of pending questions. So our final panelist, Professor Jansen Kalamita, it's CIL Head of International Economic Law and Policy. And Jansen is going to talk not necessarily about human rights, but more about investment from an investment perspective, investment law perspective, but also the in resolved question of the ICJ advisory opinion and the Inter-American Court advisory opinion from his perspective. So Jansen, you have the floor, and thank you very much in advance.
Thank you, Helen, and thank you to Danielle for inviting me. Perhaps fittingly, I'm speaking to you from The Hague. So I'm at ground zero for the advisory opinion. But I'm very grateful for the opportunity to share publicly for the first time my preliminary thoughts about the implications of the advisory opinions for international economic law. And I say preliminary, not just to hedge my remarks, but because, as Nilofer noted in her opening, each time I read these advisory opinions, I see new things and think of new things as I go through them. That said, I have to say it is tempting to comment on the impacts of these advisory opinions on domestic litigation, as Francesca was talking about, which I've been thinking about as well. But maybe we'll have time to do that in the questions. As you said, in my remarks, I'm going to focus particularly on the implications with respect to international investment law, specifically treaties providing international protection for investments and investors, which create preferential treaty-based rights for investors and investments, and provide a system of dispute resolution, binding dispute resolution, through international arbitration. That said, there are implications for trade as well, especially, I think, with respect to the interpretation and application of exceptions, such as GATT Article 20 and GATT's Article 14. But there may be broader implications for international investment treaties. And moreover, as was also said already, investment treaties were mentioned specifically in the Inter-American Court's opinion and in Judge Cleveland's separate opinion in the ICJ. So just to begin, I suppose, with an opening remark about the relationship between investment treaties and other areas of international law. As Ambassador Fuentes noted, these are not hermetically sealed silos. Investment law on the one hand and human rights or environmental law, at least they shouldn't be. But it is fair to say that arbitral tribunals have not always been as assiduous in interpreting investment treaties in light of the universe of international law in which they exist. But I think that hopefully may change a bit as a consequence of these advisory opinions. And simply the strength of the institutions which are speaking in these advisory opinions, and of course, especially the International Court of Justice. But I do want to note what I think are the extent and the limits of the ICJ's opinion regarding state obligations and climate change that are relevant, that will be relevant ultimately in the way that the opinions are used or treated in investment treaty disputes. Obviously, as being stated, the court tells us that there is a stringent state obligation of due diligence, informed by the precautionary principle to prevent climate harm. But at the same time, the court doesn't go so far as to say that allowing greenhouse gas emissions by states per se is unlawful or a violation of international law. And so there remains this unresolved issue regarding how individual greenhouse gas emitting projects or investments should be treated with respect to the state's general climate change obligations. And Francesca referenced paragraph 427 of the advisory opinion, which does indeed, in the context of speaking about state attribution and not primary liability, but in the context of attribution and talking about how the failure to act may result in an internationally wrongful act, does note that this could include fossil fuel production, consumption, granting fossil fuel exploration licenses, and providing fossil fuel subsidies. But it then goes on to say that it emphasizes that the wrongful act in question is not the emission of greenhouse gases per se, but the breach of the international obligations that it's already identified. So I think, put very reductively, what that means to me is that the advisory opinion does not provide states with a get out of jail free card in terms of their international treaty obligations in other areas, and particularly international investment treaty obligations. And in the past, we've seen international investment tribunals holding that the state's discharge of its obligations with respect to one area of international law, or under environmental treaties, for example, does not mean that the state cannot at the same time, or need not at the same time, comply with its investment treaty obligations. So, for example, an early case involving Canada, SD Myers versus Canada, dealing with the transboundary shipments of PCB, hazardous waste. The tribunal there said, yes, Canada is under an obligation under the Basel Convention, but that doesn't excuse it from necessarily complying with its investment treaty obligations in carrying out those Basel Convention obligations. So, for example, Canada was obligated to choose the least inconsistent approach with its investment treaty obligations, and that if there had been an alternative that wasn't inconsistent with the investment treaty obligations, then that should have been followed. And we've seen similar approaches taken in other cases, the Eco Oro Minerals versus Colombia case, where even if the treaty said that the state was not prohibited from taking certain measures in protecting the environment, the tribunal concluded that that didn't mean that the state wasn't obligated to compensate the investor for having taken those measures. So I think, the application of the advisory opinions is ultimately going to be rather nuanced. And as I say, it's not a bright line, get out of jail free card, or a bright line for saying there will be no obligation or potential compensation. But I do think it will be useful, or it can be useful, with respect to interpretation and application of the scope of investment treaty obligations, and particularly in light of Vienna Convention on the Law of Treaties, Article 31.3c. And just to go through a few areas where I see this as possibly happening without going on too long. One area is with respect to fair and equitable treatment and the scope of investors' legitimate expectations. And much of the question in such cases is, what indeed is a legitimate expectation? And clearly, in the context of the ICJ having issued an advisory opinion referring to the existential threat of climate change, the international law duty of states to act, etc., there can be no question going forward, and indeed I think there probably shouldn't have been a question even before these advisory opinions, but there can certainly be no question going forward that a duly diligent investor should be aware of the possibility of regulatory change because of the state's obligations with regard to climate change. So the idea of legal stability that investors often rely upon with regard to the framework for their investment, the argument that the framework will remain stable with respect to climate change concerns can no longer be considered legitimate expectation by investors. I think also the advisory opinion's emphasis on precaution should assist states in terms of making arguments regarding the reasonableness of measures and regulatory changes that they might take to address climate change. This has arisen in a number of cases in the past. One example, not from the environmental sphere, but public health, the Philip Morris versus Uruguay case, where part of the attack on Uruguay's measures was that they were not reasonable or they were arbitrary because of a lack of sufficiently robust scientific data to support them. And I think here the advisory opinion's emphasis on the requirement that states not wait to have 100% scientific certainty, but rather that they act in a precautionary way and that they have a margin of appreciation to act, can be an important tool for states to justify their actions and to defend their claims, again, on fair and equitable treatment grounds. Another area where the AO may be valuable is in terms of, again, interpreting the scope of fair and equitable treatment, and perhaps even in particular with regard to the procedural protections that an investor may receive. In the past, in the Al-Tamimi versus Oman case, the tribunal there was interpreting whether or not certain procedural deficiencies in the way an investor had been treated by Oman in the pursuit of environmental goals. Well, they're asking whether those procedural deficiencies resulted in a breach of the fair and equitable treatment standard. And the tribunal said no, and in part the reason it said no was because it looked at the treaty and it said that this treaty evidences the importance that the states have given to environmental concerns because it has an environmental chapter and so on and so forth. Well, the AO on its own, I think, demonstrates the importance of climate change and environmental protection, so that even in cases in which states don't have environmental chapters or other context that they can use to interpret phrases like fair and equitable treatment, they may well be able to point to the general existential threat that all states are acting in pursuance to. And again, make the argument that a further margin of appreciation should be tolerated when the state is acting for such an important purpose. And I guess lastly on that important purpose point is how the advisory opinion can feed into the analysis of indirect expropriation and the state's exercise of its so-called police powers. And one of the issues of analysis there is whether the actions or the measures that the state takes in pursuit of the public interest, whether there's a reasonable relationship of proportionality between the measure that the state has taken, the weight or harm that it causes to an affected investor, and the aim that sought to be realized. Well, again, clearly the AO tells us that the aim sought to be realized here is nothing less than the existential survival of the human species. So this will, I think, again, hopefully give states greater scope of discretion in terms of striking the balance in terms of the measures that they adopt. And then one final point is whether the advisory opinion can actually be used the other way around, and whether the advisory opinion could be used by certain investors to support claims against states for failing to discharge their climate change obligations. And here, in most investment treaties, there's an obligation for the state to provide full protection and security to investments. And this raises the question, full protection and security requires due diligence by the state in providing the protection and security. So does that full protection and security include the obligation to take due diligence to protect investors from climate harm due to the state's, let's say, failure to address greenhouse gas emissions by other investors within its jurisdiction? Now, there are huge causation issues there, but it is worth pointing out that it wouldn't be the first time that an investor had brought a claim against the state in which it made its investment based upon the state's alleged failure to carry out environmental obligations under environmental treaty. And there's the Allard versus Barbados case there involving the Ramsar Convention and the Convention on Biological Diversity. And then just lastly, I won't go into it, but I think if we move away from the litigation aspect of investment protection treaties, I think the advisory opinion will very likely provide impetus for further adjustments in new treaty drafting and perhaps in the renegotiation of existing treaties so as to ensure that treaties are adequately reflecting the balance of rights and obligations that states wish to strike in these treaties. And one can already see this happening even before the AO in certain treaties, and particularly Article 24 of the African Continental Free Trade Agreement Investment Protocol. So why don't I leave things there? Thanks very much for the time.
Thanks a lot, Janssen. It was very interesting also because we discussed a lot about the harmonious interpretation, harmonious approach between climate change and human rights, but indeed you also insisted on the potential transformative impact of the advisory opinion of the ICJ on investment law, but also the fact that we have to be realistic. And you mentioned the least inconsistent approach instead of this harmonious approach. And it was indeed very interesting to have your point on this unresolved question left by the two advisory opinions. We have 9 minutes left, so we have actually in the chat box 3 pending questions. So I will, if you agree, dear panelists, I will summarize the questions and please be free to take any of them. So the first question is about the silos, and indeed we discussed about breaking the silos and so on, but one of the participants asked whether we are not also witnessing contradictory decisions delivered by international tribunals. So what is your view on that, whether or not we have this harmonious approach or contradictory and fragmentation approach to those questions? The second question is more about the political aspect and the political backlash by some states. So the participants say that indeed, the advisory opinion of the ICJ might be a game changer, but we still have states like the US very reluctant to participate, support the climate change regime. So would it be a challenge? And I already guess the answer. And the final question, indeed, it has not been discussed so far. The final question is about the common but differentiated responsibility element that is at the heart of the climate change regime. I'm reading the question. So how the panelists see this common but differentiated responsibility be implemented by states after the two advisory opinions. So please be free to take any of these questions and to provide, and that will be also probably your final words, so to provide your answer. Who would like to start first among the panelists?
Well, I'm happy to answer number 3 on CBDRRC. But of course, I'll be speaking on what I see that's been happening in ASEAN. So if we are looking at ASEAN's track record on climate cooperation, ASEAN tends to adopt soft non-binding commitments such as declarations, action plans, and strategies. And binding enforcement is very rare and weakly applied. And we also understand that ASEAN has these core principles of consensus and non-interference that often prevent any differentiation of obligations among members. And the other track record that is also worth to be mentioned is that climate is usually framed as developmental or environmental issues, not human rights issues. But if we are looking at the current tendencies being adopted by AMS, ASEAN member states, we are looking at several different state groups. One group are those who are very dependent on coal and fossil fuels. And this will make them reluctant to take on stricter obligations. And this group will likely highlight respective capabilities from the CBDRRC to justify slower transitions. And they may also resist language that could expose them to liability or stricter external scrutiny. Another state groups, they are those who are among the most climate vulnerable states. They are likely to invoke CBDRRC to demand more finance and technology transfer, but they are also having limited leverage to enforce it regionally. And another state group are those who have low domestic emissions but influential in other sectors, including finance as well as technology, and they may prefer to channel support more towards ASEAN finance mechanisms or technological mechanisms, but may not be willing to bind themselves to more ambitious mitigation towards the issue. And another state group are those who are very highly vulnerable in terms of climate crisis, but also very limited in capacity. And they are more likely to use CBDRRC mainly as a claim for assistance rather than to commit to stronger action. And the last group is they are fossil fuel exporter, which likely resist ambitious obligations towards following the CBDRRC, but they are also maintaining a low political profile. So in practice, what it means for CBDRRC in ASEAN, full implementation is unlikely, at least in the near future, but we may expect selective uptake where vulnerable states using CBDRRC as bargaining tool for support. We may also expect the use of symbolic recognition in which statements may acknowledge CBDRRC as principle, but without concrete differentiation in commitments. We may also expect voluntary cooperations, but framed as a solidarity, as opposed to binding obligation. And we may also expect fragmented practices where sometimes some states may push harder in global forums, especially those who are more vulnerable, and other states may prioritize development and energy security. So these are my take on the question number 3. And yeah, so I think regionally, ASEAN will adopt the language of CBDRRC in declaration and frameworks, but it will operationalize it in small steps, such as capacity building or regional consultation and such. So, but hopefully, as I said, that I'm very optimistic, over time, there will be external pressure that may push ASEAN member states to align more closely with CBDRRC in practice. Thank you.
Thank you. Thank you, Ambassador Wahid. Ambassador Fuentes, do you want to address one of the 3 questions?
Yes. Did I activate my audio? Yes, I think yes. Okay, well, thank you very much for all the participants, because of all these interesting ideas that were put on the table. In particular, I would like to comment on one of the questions, on some of the questions. One regarding these silos, and if fragmentation will continue, because fragmentation is sort of a normal description of how the international system works. You can see the Inter-American Court of Human Rights have many interpretations that in a way can be contrasted to decisions by the European Court of Human Rights in many respects. Of course, that fragmentation, those differences will continue because there are different traditions in different law systems, because we have also, I mean, judges, they differ among themselves. For example, if one question could be, can we expect investment arbitration to show dramatic changes in the way in which the tribunals assess domestic legislation with regard, for example, to measures regarding the protection of the environment? Some people might be skeptic, and they can say no, because the investors will still sit on the tribunals, judges that they know that will favor them. Okay, could be. However, I would like to tend to be optimistical, because how this system works up to now, I think that it has worked in a very insulated way. And all these advisory opinions point to a different point of view, which is integration. Therefore, I think that we can expect, be sort of a little bit optimistical, that tribunals will tend to be more sensible to the arguments that are already in these advisory opinions. There might be some drawbacks also in the jurisprudence. I think that the Inter-American Court of Human Rights tends sometimes to move the boundaries a little bit too far. Therefore, particularly thinking on the rights of nature as a subject of international law, I'm sure that that will not be taken by investment tribunals, really. Okay, but okay, that because they are moving too far the boundaries. However, in other respects, I think that it will be very difficult not to consider that their state has an international obligation and also a constitutional obligation to take measures to tackle climate change. Now, problem with investment law also is that it is governed by existing treaties, and you can see that there are different generations of treaties. However, the existing treaties and the old treaties sort of still survive. And you have also these clauses about the survival of the treaty even after it has been terminated. I think that that might be a problem to new jurisprudence. And finally, with regard to the common but differentiated responsibility, I think that, well, there was some clarification in the ICJ advisory opinion with regard to this, because in particular, some countries, as an ambassador, I cannot mention the countries, but some countries stated that common but differentiated responsibility really sort of was a carte blanche to continue sort of polluting the environment. That interpretation, I think, that has been completely dismissed. So, but common but differentiated responsibility still has a very important role, particularly in how countries design their NDCs. So, of course, the developing world, for example, countries, emerging economies, you cannot be so stringent in terms that they are still developing. However, they have already access to cleaner energy. So they could not say, well, I will use fossil fuels in a way, in the same way in which we used them in the 19th century. That will be an argument that will not be acceptable. So that is my contribution to responding the questions. Thank you very much.
Thank you. Thank you very much. We are really privileged to hear from you both on this question. We are just a little bit out of time. So Francesca, I have seen you raise your hand. So if you have things, yeah, and indeed Janssen, if you have things to add to the very sophisticated answers we heard, the floor is yours. Francesca,
thank you.
First, and then Janssen.
Thank you. We'll be very brief. Just to touch upon the second question, there's this sentence that always I find very poignant, which is "tiny is mighty." I think we should also change the narrative that change cannot happen if strong powers are opposed to it. And the fact that the ICJ also came with such a strong advisory opinion in this very tense political moment is even more relevant. And looking at climate action, we see a number of initiatives to better address climate change. We can think of the Fossil Fuel Non-Proliferation Treaty Initiative, for instance, where we see developing and developed countries really coming together to try and set a system whereby fossil fuel phase out is actually possible and profitable. And so I think this narrative whereby if we have only strong powers against change, then nothing can happen is really dangerous. And we should see at what's happening already, which is against this trend. So that's how I see hope, and maybe giving a bit less importance to this very resounding statements would actually be helpful to then elevate maybe more tenuous, the stronger voices. Thank you.
Thank you. Briefly, yes, I suppose I generally agree with Ambassador Fuentes, although I wouldn't describe my position as optimistic necessarily, but cautious in terms of how these advisory opinions are used. Just on the political point that was raised, I think timing is everything, and from the political sense, well, first of all, it was quite fortunate that the American judge on the court was a Biden appointee, because had the American on the court been a Trump appointee, we can guarantee that it wouldn't have been the unanimous decision that we had. But I think it is a important decision, the AO, especially from the ICJ, because it comes at a time when a lot of air seems to have been taken out of initiatives with respect to international economics and international finance regarding moves towards climate change. And I think that the AO provides a new point of argumentation for policymakers and negotiators when considering how to address climate change in the negotiation of new treaties and perhaps in the renegotiation of existing treaties. And my last point would simply be just again on the point of attribution in the court's decision. The court is very clear in reminding us that all of the state's organs are responsible for the obligations of the state here. And that includes the courts. And the reason that resonated with me was in light of the appellate decision of the Dutch court in the Mille Defense versus Shell case, in which the court affirmed the lower court's decision that, yes, Shell has an obligation to reduce greenhouse gas emissions, but then said that it was improper for the lower court to set a number on that, 45% global emissions reduction. And the reason the appellate court said it was inappropriate was because there was scientific uncertainty as to what the percentage should be. And I wonder if an advisory opinion like this, because it does apply to the courts, and because it emphasizes the need to apply the precautionary principle in carrying out the due diligence obligation, this may hopefully cause some domestic courts to rethink whether simply because they don't know exactly, they shouldn't act, or whether the threat is grave enough to err on the side of action as opposed to inaction. Sorry, not related to a question asked, but I wanted to get that in.
No, thank you. Thank you very much. And thanks again to all the wonderful panelists. It was really a fascinating conversation with a lot of question marks, actually, and pending questions. So let's continue the conversation. Thanks for your generosity, because we are running a bit out of time. And thanks also for the participant for your questions. So yeah, let's see how the African court actually will deliver its own advisory opinion. And thanks to Daniel and CIL for hosting these free webinars that I'm closing, actually, if Daniel has no further comment. Thank you very much. And thanks to all the persons involved in the preparation. Thank you.